And a lot of people are wondering how my lawyers are going to handle this. You know it. I ain't got them. So let's ride this. I'm excited to see how it goes. I'll see you in court, pal.
Well, he got them. And he got good ones too. Pat McAfee might be funny and entertaining, but man, his lawyers are all business because they just pulled the pin on a grenade and dropped it in Brett Favre's lap. That grenade comes in the form of a fantastic motion to dismiss in response to Favre's lawsuit. So let's break down why Pat McAfee and his team are asking the judge to throw out Favre's defamation lawsuit. I'm Josh Stanford, I'm America's attorney. Don't forget to lawyer up and subscribe to this channel for more updates about this case in the future. McAfee's motion to dismiss makes four main arguments. The first hole that they punched in Favre's sob story of defamation was that he and his lawsuit unfairly and misleadingly cherry-picked quotes from McAfee's show to create an illusion of defamation. McAfee's lawyers argue that given the full context of all that McAfee said on the November 30th show, which is required by Mississippi law, the comments that he made about Favre are not defamatory. The motion to dismiss specifically points out two of McAfee's statements that were singled out in Favre's lawsuit. The first is this: every time his name gets brought up, and we have to mention that he tied the hands of the poor people and took money right out of their pockets. Wow. And the second, Favre is certainly in the middle of stealing from poor people in Mississippi right now. Yeah, I mean, that could sound a little defamatory, right? Until you introduce the context that I just mentioned. McAfee made sure to let his audience know that, and this is his quote, Brett Favre Enterprises is alleging that all this is wrong, and that his statements are made, and this is another quote, from information that we currently have. Pat's argument in his motion is that he is saying two things which hedge away from asserting as true a specific fact. Number one, that Favre disputes the allegations made against him, meaning that they're only allegations. And number two, that Pat's statements are premised on incomplete information, meaning that we might have more to learn. The motion argues that because there are these asterisks around these statements, they're not defamatory in the eyes of the law. They don't fail to mention the iconic tweet that I mentioned in my last video explaining Favre's lawsuit. But here's the thing about a tweet like that. McAfee isn't attempting to state a fact. It's innuendo. It's comedy. It's a meme. It's not defamation. And really, you can make the same argument about the verbal statements on the show. Pat's not actually saying that Favre tied up poor people and put his hands in their pockets. And the idea that Favre is currently stealing from poor people, look, it's derogatory. It's very derogatory. But defamation and talking bad about someone, those are two different things. No reasonable person would listen to the November 30th show and think that poor people are currently tied up in a Mississippi warehouse like some scene from a Scooby-Doo. Over here! Right behind you. It's figurative language. It's not factually assertive. I mean, it's mean, but mean ain't illegal like that. Now, the motion goes on to claim that McAfee's statements are privileged under the First Amendment because they were made based on allegations from the Mississippi Department of Human Services lawsuit against Favre and information given by the auditor's office. Now, this is a very technical argument. Pat's lawyers argue that because he is commenting on the governmental actions against Favre, that as a legal issue, meaning no presentation to a jury for any kind of a decision, McAfee could not have committed defamation. This defense is not universal, but is somewhat unique to Mississippi in that the state has a policy of wanting to encourage truthful and open debate about matters of public concern. So, as long as McAfee's statements were not misleading about the proceedings against Favre, then he should be in the clear. Sidebar. This is a good time to point out that, although not one of the four grounds for dismissal that McAfee is relying on, the lawyers argue that some of Favre's co-conspirators have in fact pled guilty to versions of the crimes that are currently being reported in the news. This is a framing technique that they are attempting to use with the court. Hey, don't feel bad for Brett Favre. Everything bad that's been said about him is obviously true. Something along those lines. And then this theme is underscored by their use of the official proceedings commentary defense that they use in the motion. And just as an aside, the MDHS lawsuit against Favre is, ugly. I mean, ugly. They've accused him of being part of the loss of millions of dollars from where the money was supposed to be. The next foundational issue that the motion points out is a lack of actual malice. Now, if you've seen my prior video about Favre's litigation strategy, you already know what's going on here. Favre's lawsuit doesn't claim that McAfee had actual malice, and this motion to dismiss says that's because he can't claim that. Now, actual malice isn't something that an everyday person is going to have to worry about if they're filing a defamation lawsuit. The standard only has to be proven when it comes to public figures, which Favre is. We all know that Pat McAfee didn't know whether the allegations against Favre were true or not. How could he have? So that means Favre has to prove that McAfee's statements were made with reckless disregard about something that McAfee had serious doubts as to the truth of the publication. Now, not only would Favre fail if he attempted to prove actual malice, but the motion to dismiss points out that Favre didn't even plead it. To explain, proof is the evidence offered at trial. We don't know what that's going to be. That's off in the future. But pleading is the way that a claim is framed in writing when a lawsuit is filed. Favre didn't mention that McAfee knew the claims were false or these showed reckless disregard as to their veracity. McAfee's team of lawyers claims that Favre could never competently plead that due to the fact that the allegations were made public by the MDHS and the auditor's office and other media reports. Does McAfee, who stars in a self-described comedic sports commentary show, have to go and do his own investigation to discover whether the Mississippi auditor is lying in his claims against Favre? Obviously not. Now, these three claims by themselves are very strong. It's actually a pretty rock-solid motion to dismiss. But there's just one more nail left in the coffin of Favre's lawsuit, and you had better believe McAfee's lawyers hit it. They nailed it. And it has to do with this moment right here.
So I would like to let the New York lawyers that wrote me 2 letters.
So let's talk about Mississippi Code Section 95-1-5, subsection 1. This law states that before any civil action is brought for publication, the plaintiff shall, at least 10 days before instituting any such action, serve notice in writing on the defendant at its regular place of business, specifying the article, broadcast, or telecast, and the statements therein which he alleges to be false and defamatory. This means that 10 days before filing his defamation lawsuit, Favre had to inform Pat McAfee about this proposed lawsuit. This is called a safe harbor provision in the law. And we can see from that clip that McAfee was in fact informed prior to the filing of the lawsuit. So what's the problem? Well, according to the motion to dismiss, those letters were sent only 6 days before the lawsuit was filed. That's 4 days too early. And you might think, hey, what's the big deal? Favre warned Pat that he was going to sue him, and Pat didn't take any steps to remove the allegedly defamatory statements from the places where they were published. So what would an extra 4 days even matter? Pat didn't even try. Now, honestly, that's a nice practical and reasonable argument, but the problem is this. When you have a statute that tells a plaintiff what rules they must comply with prior to filing a suit, well, to be clear, they really must comply with those rules. That's bad news for Favre. Now that this motion has been filed, Brett Favre has just a few more days to respond. I'm very interested to see what Favre says. I do believe that McAfee has the high ground in this case, both legally and morally. But Favre is represented by lawyers who like to fight. Hey, they're paid to fight, and they're unlikely to give up. As I've repeatedly said, though, this is a very well-written motion to dismiss. And I think, for me, it's time for a round of applause for the attorney at K&L Gates and Bradley Arent Bolt and Cummings LLP. Okay, but wait, there's more. If you recall, the McAfee lawsuit is just one of 3 by Brett Favre. If the McAfee motion is successful at all, you can pretty much guarantee that Shannon Sharp and Shad White will try to use some of the same arguments in defense of the cases against them. Well, I'd like to know, what are your thoughts on this motion to dismiss? Are you on Team Favre or Team McAfee? Let me know your pro se opinion in the comments below. And I will be back soon with more updates, so don't forget to lawyer up. You can also check out my original video right here explaining Favre's lawsuit. See you soon. Bye.